Code of Criminal Procedure 1973. It is the interest of justice that dispute should be settled amicably and speedy. The Code of Criminal Procedure includes provision for speedy and amicable resolution of dispute under Section 260, 265A, 320, 257, 258, and 321. In order to avoid delay in disposal of criminal provision shown in the following chart: 1. Summary trial, plea bargaining; 2nd, 3rd, compounding of offences, withdrawal of complaint; 5. Stop the proceeding. Summary trial. Summary trial aims of speedy disposal of cases. It is not for complicated cases which require in-depth inquiry. Section 260 of the Code provides that any chief judicial magistrate, any metropolitan magistrate, any magistrate of the first class, especially empowered in this behalf by the High Court, may, if he thinks fit, try in a summary way offence which can be tried similarly are: 1. Offences not punishable with death, imprisonment for life, or imprisonment for a term exceeding 2 years. 2nd, offences under Section 379, 380, 411, 414 of the Indian Penal Code, where the value of the property stolen does not exceed 2,000 rupees. 3rd, offences under Section 454, 456, 504, and 506 of the Indian Penal Code. 4. Abatement of any of the foregoing offences. An attempt to commit any of the foregoing offences, and when such a attempt is an offence. Number 5. Any offence constituted by an act in respect of which a complaint may be made under Section 20 of the Cattle Trespass Act 1871. Plea bargaining. Plea bargaining, which was inserted recently in the Criminal Procedure Code in 2005. Object of plea bargaining is amicable and speedy disposal of cases. This provision should apply in respect of any accused against whom the report has been forwarded by the officer in charge of a police station under Section 173, alleging therein that an offence appears to have been committed by him other than an offence for which the punishment of death or of imprisonment for a term exceeding 7 years has been provided under the law for the time being in force, or a magistrate has taken cognizance of an offence on complaint. After hearing the parties of the court is of the view that Section 360 or the provisions of the Prohibition of Offenders Act 1958 or any other law for the time being in force are attracted in the case of the accused, it may release the accused, or it may sentence the accused to half of such minimum punishment. The judgment delivered by the court under plea bargaining provision shall be final and no appeal, except the special leave petition under Article 136 and writ petition under Article 226 and 227 of the Constitution shall lie in any court against such judgment. Compounding of offences. The provision of amicable settlement of criminal cases through compounding of offence under Section 320 of Criminal Procedure Code, offence covered by the Table 2, such Section 1, can be compounded even without permission of the court. Under subsection 2, permission of the court is necessary for compounding a case even by consent of the parties, because the offences mentioned under the subsection are grave ones. Those offences which affect the individuals alone and are not of grave nature may be compounded by consent of the parties under subsection 1 of this section. Withdrawal of complaint. Sometimes parties to dispute in heat of passion and anger file case against each other, but later on when their passion cool down, the amicable settlement of dispute comes to their mind. The Code of Criminal Procedure 1973 provides such provision to dispute amicable. It provides that if a complainant at any time before a final order is passed in any case under this chapter satisfies the magistrate that there are sufficient ground for permitting him to withdraw his complaint against the accused, or if there be more than one accused, against all or any of them, the magistrate may permit him to withdraw the same and shall thereupon acquit the accused against whom the complaint is so withdraw. Similar power is given to the public prosecutor by the Code of Criminal Procedure. Number 5. Stopping of proceeding. It is the interest of justice to put and the litigation. So the Code of Criminal Procedure provide power to stop proceeding when it is not in the interest of justice to carry on the proceedings. It states that in any summons case instituted otherwise than upon complaint a magistrate of the first class or with the provision section of the chief judicial magistrate, any other judicial magistrate may for reason to be recorded by him to stop the proceeding at any stage without of acquittal, and in any other case release the accused, and such release shall have the effect of discharge.